Further to these videos. BC Humanist Association. Humanists argue for ex-religious privacy rights at BC Court of Appeal. October 30, 2024. Lawyers argued over the constitutionality of BC's privacy law at the BC Court of Appeal yesterday in an ongoing dispute between the Jehovah's Witnesses and the Office of the Information and Privacy Commissioner of BC. The BCHA was able to bring the voice of those who've chosen to dissociate from religion to the court. The case began several years ago when two former members of the Jehovah's Witnesses, JW, requested records held by their former congregations in Grand Forks and Coldstream under BC's privacy law, PIPA. The JWs believe their religion requires the records to be kept confidential and have fought the required disclosure to the Privacy Commissioner, arguing the privacy law is unconstitutional. The BCHA intervened at the Supreme Court of BC in September 2023. That court dismissed the JW's petition and that decision was appealed. Yesterday, the Court of Appeal heard those arguments. Our arguments, presented by our pro bono counsel John Truman and Chloe Trudell, walked through our perspectives on freedom, consent and religion, assessing the severity of the claimed charter infringement in this case, and how the court might balance that infringement against the importance of privacy rights. We suggest that PIPA recognizes the inherent power imbalance between organizations and individuals. Far from being a state intrusion into the private affairs of religious congregations, PIPA tries to protect individuals, members and non-members, from having their personal information used, or misused, without their consent. Unfortunately, the court does not record, nor permit, recordings of its proceedings. However, we posted a few updates throughout the proceedings to threads, including our brief arguments. The real claim, by the Jehovah's Witnesses, is that they have the constitutional right to keep secret files about former members without consent, and without any regulation by the state. The justices reserve judgment, meaning it will be another 3 to 6 months before we have a decision. That may be appealed to the Supreme Court of Canada. The BCHA will continue to follow this case with great interest. Read our factum.